This is a lecture for my professional responsibility class. We're talking about representing an entity as a client, an organization. And so this is part 2 of our series on Rule 1.13 or 1.13. And I'm calling this Going Up the Chain of Command, because this is a group of provisions in this very long rule, subsections B, C, D, and E, that deal with the corporate hierarchy. And I'm using this graphic because this sounds great in theory, and when we put it in writing, when you're in practice, sometimes this can get kind of confusing. Just to big picture this, because the rules are very kind of phrased in a wordy, confusing way, we're talking about you represent an entity, whether it's in-house counsel or outside counsel. We'll call it Dunder Mifflin, for example. And we have a constituent and lower level employee who's creating problems that could create actual legal liability for the company. That's what this section of rules is going to be about. Well, what are you supposed to do? Start with that person and see if you can talk sense into them. What you're doing is illegal, or that's stealing from the company, you can't do that, or something like that, and get them to change their behavior. If they don't, then you're supposed to start going over their head. So you go next step up. So if it's an assistant to the regional manager, maybe, and this could get kind of confusing and debatable, whether the assistant regional manager is over them or is a peer, but certainly by the time we get to the regional manager, that's above an assistant regional manager or assistant to the regional manager. And then there's going to be a regional VP maybe, and maybe a CFO that's over that person. The top is going to be the board of directors. You don't skip steps and just go straight to the top and tell the board when our low-level employee, who I'll call Dwight in this case, is doing something wrong or doing something illegal. You should go one step up the chain to try to correct the problem and contain it or confine it. The same is true if you're representing some sort of governmental entity, let's say a school district, and you're either in-house counsel or outside counsel for a school district, and it could be a county or a city or municipality or a government agency. And you have a lower level employee who here I'll call Willie, and who's just very difficult and is doing something that could create legal liability for your entity client, your client entity. So who do you go to? You go to one step up. Let's say if it's a school, the principal of that school. If that doesn't get you anywhere, then you go to the superintendent and so forth. And then it gets a little unclear with a government entity, who's next, right? So is the school under the state board of education, or are they part of the local municipal government, like under the mayor or city council or something like that? And the rules don't really answer that ultimate question. So here's provision B. This is so long, I had to break it into 2 slides for you. If a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in an action or intends to act or refuses to act in a manner related to the representation, that is a violation of a legal obligation to the organization. So let's say they're stealing from or embezzling money, or a violation of law that reasonably might be imputed to the organization. So let's say they're dumping hazardous waste material or harassing another employee or subordinate, and it's likely to result in a substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. Unless the lawyer reasonably believes that it's not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. So again, this is our chain, going up the chain. Let's look at some of the comments. Comment 4 for this rule says, normally you are probably gonna, if you catch an employee doing, for a corporate entity you represent doing something illegal, you're probably gonna have to go over their head. But Sometimes you can just talk sense into them. And if you get a question on the MPRE about this rule, always watch for that as an answer. If they give you that as an option, it's the right answer. In some circumstances, it may be appropriate for the lawyer to ask the constituent to reconsider the matter. For example, if circumstances involve a constituent's innocent misunderstanding of law and subsequent acceptance of the lawyer's advice, the lawyer may reasonably conclude that the best interest of the organization does not require that the matter be referred to higher authority. And so going back to our example for a moment, you have a problem, you see, we'll call him Dwight, is doing something illegal or something that is, in theory, stealing from the corporation, and you talk to Dwight and he says, oh, I didn't know, I'll stop. Then you actually don't have to escalate the matter any further. You only do that in the commonplace situation where he says, I don't care what you think. And that's where our comment picks up. If a constituent persists in conduct contrary to the lawyer's advice, it will be necessary for the lawyer to take steps to have the matter reviewed by a higher authority in the organization. And then here's an emergency exception to the chain of command rule, which is to go step by step, don't skip steps up the chain. If the matter is of sufficient seriousness and importance or urgency to the organization, referral to a higher authority in the organization may be necessary, even if the lawyer has not communicated with the constituent. So you realize, you're walking around the workplace one day and you realize that a certain employee has wired their desk to explosives. They've booby-trapped their desk so it's going to explode. Well, guess what? It's okay for you to alert the management to this fact, and without going and finding the employee who has wired a bomb to their desk, obviously. And so that's an extreme case, but you could imagine other situations where the situation is so urgent that you don't have to wait and try to talk sense into the person first. You can go over their head. Now, the highest authority to whom a matter may be referred ordinarily will be a board of directors. In some organizations, we call this a board of trustees. It's basically the same thing, or a similar governing body. That's the last resort. C, except as provided in the next section, if, despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or refusal to act that is clearly a violation of law, and the lawyer reasonably believes that the violation is reasonably certain to result in a substantial injury to the organization, then the lawyer may reveal information related to the representation, whether or not Rule 1.6 otherwise permits such disclosure, but only if and to the extent that the lawyer reasonably believes necessary to prevent substantial injury to the organization. So notice, we're essentially creating another exception to the confidentiality rule. And this is where you've gone up the chain, you've gone all the way to the board of directors, and they laugh you off or tell you to get lost or something like that. Then you may need to make a disclosure, do a preemptive disclosure, think of this as whistleblowing, to a regulatory authority in order to save the entity. And that's why I have at the top of here, if you don't get it, if you hit a wall when you get to the board of directors, you may need to go to the relevant government agency, the SEC, the IRS, the EPA, whoever the relevant agency is for this problem, in order to protect the interest of who's your client? The entity is your client. And to make sure my students understand this, with some of these regulatory agencies, if you have an extreme case of wrongdoing or unlawful activity, they might actually pursue dissolving the corporation or have a government receivership of the organization or something that would be otherwise fatal to your client, which is the entity. And there's a news item while I'm recording these videos in August of 2020 about a large, very old or national organization that advocates for gun rights that has a lot of legal problems and is involved in a lot of litigation. And the Secretary of State of the state where they are incorporated is currently seeking the dissolution of this nonprofit or large nonprofit organization because of many, many allegations and evidence of self-dealing and embezzling and otherwise illegal activity on the part of the organization. And that's kind of the nuclear option or the ultimate option. And as a lawyer, you need to be aware that there are state secretaries of states and some federal agencies that could actually kill an organization. In order to prevent that, you might need to do a preemptive move of disclosing something so that a problem with certain individuals can be addressed. Let's go back to our rule. D. Paragraph C shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law or to defend an organization or an officer, employee, or other constituent associated with the organization against a claim arising out of an alleged violation of law. What are we talking about here? I want you to think for a moment about the Upjohn case, Upjohn versus United States, that we talked about when we did attorney-client privilege. So Upjohn is a large international conglomerate, a manufacturing company. They produce chemicals and things like that. And they became aware that there was some illegal activity going on, bribery of government officials, by a manager in a overseas branch, in one branch. They asked their in-house counsel. They knew that there would be an enforcement action about this, that they would be in trouble with the federal government. So they asked their in-house counsel to do an internal audit and figure out how widespread the problem was and how they should address it. In that case, the lawyer, the top entity, think about it, the board of directors is addressing the problem. So this isn't a case where the lawyer should have to make a disclosure and kind of betray the client and violate confidentiality in order to save the entity. And so the lawyer in that circumstance, the duty of confidentiality applies. So if you're hired by a corporation that's already in trouble, and then during the course of your representation, you get a lot of evidence that proves the wrongdoing and the responsibility of certain corporate actors, you don't have to disclose that. You don't have to go up the chain, right? Because you've been brought in after the problem has become known to someone, and we're doing this now in anticipation of some kind of enforcement action. Okay, let's go back to the rule. We're almost done. E, section E. A lawyer who reasonably believes that he or she has been discharged because of the lawyer's actions pursuant to paragraphs B or C. In other words, you started going up the chain to address wrongdoing by a lower level employee, or who withdraws under circumstances that require or permit the lawyer to take action under either of these paragraphs, shall proceed as a lawyer reasonably believes necessary to assure that the organization's highest authority is informed of the lawyer's discharge or withdrawal. So what are we talking about here? So you encounter wrongdoing with a certain, let's say it's a mid-level manager, and you go over their head and talk to the vice president or something like that, who's the next person up the chain, and that person says, you know what, we really don't like people like you asking so many questions, you're fired. Well, that means you're fired. You no longer represent the entity. So even though your representation has concluded, you have a duty to inform the board of directors. So under E, we are going to skip all the other steps because your representation has ended, or you've been put in an impossible situation ethically and you've had to withdraw. Like someone said, oh no, I know it's illegal, but you're going to fill out the forms that way, or something like that. You're going to withdraw and you're going to send a farewell letter to the board of directors, or ask for a meeting and explain to them, you have some employees here who are doing something illegal. I have to withdraw, or I've been fired for looking into it, just so you know, goodbye. And so this is the kind of farewell letter, and I'm going to tell you why I'm leaving, requirement. Comment 8 basically just restates E, and it explains it again. If you are fired or you withdraw under the circumstances that otherwise you would have kept going up the chain to address it, now it is okay to skip the steps in between and just contact the board directly. Well, I watch for this on test questions on the MPRE. If we're really operating under the regular circumstances of B and C, you are going to go step by step, and it would be a wrong answer for the Lord to immediately, like after finding out a problem with Dwight, that you're going to go all the way to the top of the corporation. You're supposed to hit every step in the chain in between, go up the chain of command. Unless you go up a couple steps and somebody says, you know what, you're fired. Now you, as you're upon your departure from the representation, you do need to notify the top of the chain of the corporate entity why you left and what's going on. Comment 9 explains that this gets complicated with government entities. It's difficult in the government context to define who the client is sometimes. Think about it. So let's go to our example of the school district. It's one thing to say, okay, Houston Independent School District is my client. So what happens, who's over the school district? Is it the city of Houston? Is it the State Board of Ed or what? Or let's say that you're doing legal work for the Securities and Exchange Commission and you find corruption going on inside this government entity, and now it's unclear. So maybe if it's the head of a bureau is the problem, then probably that bureau is a subset of a larger department. And so that department, or maybe the relevant branch, like the executive or legislative branch, may be the client. They can't really answer that for you. You won't be asked that on the test question. Just be aware that in practice, when you're dealing with the government, it's a little confusing. And then keep in mind that you could always argue when you're talking about a public entity like a government entity that the people are really your client, right? But that doesn't mean that if somebody on the street says, you work for me, buddy. No, you really don't. You work for the entity, but maybe the entity is supposed to work for the people, and it gets confusing. In those situations, we often have things like whistleblower statutes or duty to report something to, say, internal affairs or an inspector general's office or something like that. And as a government lawyer, you may have a higher duty to investigate wrongdoing and to report it somehow. Okay. One parting word for my students. Again, it sounds all well and good to say just go up the chain of command step by step. Sometimes that will be very clear. Sometimes it's not. And I want you to think about, give an example probably familiar to you as a student. Think about whether either undergrad or while you've been in law school, a situation where you wanted to do something special. You wanted to start an organization, host an event, drop a class after the drop ad period or something like that. And you get sent all over the administrations. Everybody says, I'm not sure, maybe you should ask so-and-so. And then you go ask that person, they send you to somebody else. And then that person sends you to somebody else. And then before you know it, you're being referred right back to where you start. And that's not going to end when you're a student. That happens when you're corporate counsel too, where you could get referred all over the building, as this picture kind of illustrates, all over the hierarchy. Also, you could, if you think about like in a college or university where you could have several associate deans who have different sort of specialized responsibilities. And it may seem like if you have a problem and you go to them that the next step up would be just the regular dean, but sometimes the other kind of people, the peers on that tier of the hierarchy, expect you to tell them what's going on with other people at their level. And so in practice, this can get very confusing. Okay, that concludes our lecture on the second part of Model Rule 1.13.